Hindu Succession Act is the it has come on the 17th June.
17/6/19.
But God will have to take into consideration. The area is Rajma.
देखिए वो सब कहानी हम इसमें नहीं सुनेंगे. I will not listen to all that because that is not a substantial question. We are only concerned with the succession under the Hindu Succession Act or under the Mitakshara.
Yes.
By virtue of birth of this daughter in the family prior to coming into force of Hindu Succession Act. My first question to you.
Yes.
What would be the status of the father?
Yes. Since the father was alive of the daughter born on this 8th January 1956, the property remained with him. Had he died before 1950?
Had remained with him as what? His personal property?
Yes. He
Or ancestral property?
No, as his, it will be considered as his self-acquired separate property, because when he inherited the property in 1934 after the death of his father, there were nobody like the sons were
So I'm just noting it. According to you, it was his self-acquired.
Yes.
Irrespective of the birth of his daughter prior to coming into force of 19.
He inherited in 1934.
Maybe, whenever he inherits.
Yes, yes.
You see, a property which he inherits
Yes.
may become a part of his co-pastory property the moment the children are born in the family.
No, at the time when he inherits the property, he acquires it as his absolute property. I'll come to that.
When you say that he acquires it as absolute property,
yes,
and it is neither a co-pastory property nor an ancestral property,
yes,
then which is the provision of law in particular you are referring?
this is under the Mitakshara law only.
So
I
for
have
this,
referred
yes,
to the judgment.
which judgment in particular
Yes.
can he tell you?
Yes, yes. I just. This is 2022, volume 11, Supreme Court cases 520. This I have already, your lordship.
Yes, I just want to revisit that.
Yes.
5 to
20, 520.
5.
Yes. From this, I will show that how the property devolves.
Para number? Para number?
Actually, in this case, what had happened, the right of the daughters were discussed. So, in this case, we will see that earlier, prior to the commencement of 1956, the property of a male dying devolved on his male issue only. And thereafter, in the absence of male issue, it would go to widow, and thereafter to the daughters if the male issue is not there and the widow is not there. Firstly to the male issue only, and if he is there, then it will not go to anyone else. Your Lordship, kindly see page 4 of this judgment.
In the present case, since the succession of the suit property opened in 1967,
Yes.
upon death of K, the 1956 Act shall apply, and therefore the daughters, being a class 1 here, shall also inherit the property. In the present case, in your case,
Yes.
when did the succession open?
First time in 1934,
Right?
and second time in 1992 when Surya Narayan Ghosh died.
No. The succession in your case
Yes.
opened in the year 1934,
Yes.
when the original owner of the property died.
Died. Yes. That
When
was
the
his
property remained with his son throughout,
Yes. Throughout. Yes.
throughout,
Yes.
he acquired by inheritance.
Yes.
Right? Now, before coming into force of 1956 Act,
Yes.
a daughter was born in the family.
Yes.
Does she have a right of maintenance
Uh, yes, that is there.
from the property?
Yes.
So does it acquire the status of a joint family property?
A joint family, your lordship, when he inherited the property, like that time there was no joint
That's
family
right.
existing.
But the moment the daughter is born in the family,
Yes.
does the nature of property converts into a joint family?
After the
Birth of the
birth of the daughter. We'll have to see the definition of joint family then, your lordship. So I'll come to that.
And
Yes.
if the property gets converted into joint family property prior to coming into force of the 1956 Act, then under such circumstances, upon birth of more children in the family, the status of the property continues to be a joint family.
I would like to make one submission in this case, your lordship. Then there
I'm
has to
making
be.
my thought clear
Yes,
after.
yes, I'm understanding.
Yes.
Your lordship, in that case, if there was a joint family existing, there is no pleading with regard to that. When did the joint family came into existence? Whether
The joint, you see, we are seeing the facts on the face of it, admitted
Yes.
facts on record.
yes,
There is nothing, these are absolutely admitted. Because first question is whether it is an ancestral property.
yes,
That
yes,
is the
only
first
the
question.
first question. Yes,
Right? They say it is an admitted fact that it is an ancestral property.
yes,
Right? So there was no difficulty in the court to come to that finding. Now the point is that if this is a joint family property and it devolves from the grandfather, then under such circumstances it acquires the status of ancestral.
No, your lordship, for a moment.
It is not an ancestral property according
No,
to
no, no. To qualify as ancestral property, it has to be inherited by three.
To qualify as co-pastoral property, it has to be in. But all ancestral properties are not co-pastoral
No,
property.
they are not. They are not.
But
Co-pastoral.
still,
Yes.
it is a joint family property and it is an ancestral property. Ancestral property is much wider than a co-pastoral. So, it is an ancestral property. Now the point is whether it is a co-pastoral or not, that is not the substantial question of law.
That is not.
My substantial question of law is whether it is an ancestral property.
property. Yes.
Correct?
Yes.
So if it acquires the status of an ancestral property, then on this property, the children born prior to 1956, they have a right over the property. They are not deprived. And if any property is gifted, to deprive one of them, then will that gift be null and void?
First, we'll have to see that whether it was a joint family and whether he was competent to execute the gift deed or not, despite the fact that the daughter was born on 8 January 1956, your lordship. First, we'll have to see, just because
That's
the
right.
daughter had the right to maintenance, will that make the family a joint family? Because the father will have to look after the daughter. So that doesn't make the family a joint family. Because in this case, the father will have to look after the daughter, your lordship. That will not make the family joint family. Joint family means other members of the family staying together and having a common common kitchen and common property. That will make the property.
Father with children does not constitute a joint family amongst them.
Father with the children. Like only I think when they get married and all, and they are staying and they
ऐसा
have
तो concept
sons.
नहीं है।
We'll have to see the definition of joint
ये
family
कुछ
property.
basic facts थे जो मैंने point out किए हैं। अब आप हमको अपना written submission से proof trace करना है।
Submissions.